43 of 2026.
Appellants are directed to file amended cause title challenging the decree. Yes.
May I please, Lordship? Lordship, my senior is on leave. Kindly fix it for another date.
Any objection, Mr. Bora?
I've been informed last time that their part is already been over. Our senior has informed me.
Yes.
Their part is over.
They just informed to me, the senior itself. So I don't know what is the instruction to have.
And our part is over. If you
Their part is over.
continue, then
No, on the other day, he has filed on a written argument.
Yes.
Okay.
This is the only part.
Okay.
Probably there are 2 points involved in that regarding the confession of an co-accused and the presumption regarding the election. Well, that is the only 2 points probably they are harping on.
Are you ready to argue the matter
I'm
today?
ready, otherwise if they have any objection, my lord, I can continue my.
Any objection?
it's good if my senior is here because I'm new.
When your senior will be available?
She's coming tomorrow. She'll
Tomorrow.
be available from 16.
16th. Okay. Miss, your name, please?
P. Majumdar on behalf of M.
P.
Kumar.
Majumdar, Learned Counsel, appearing on behalf of Miss M. Kumari, Learned Conducting Counsel for the petitioner. With consent from the other side, press for listening the matter on 16th.
Around 17, my lord.
17. Okay.
17 motion. Just half an hour matter, my lord. Not even half.
No, in motion matters, it is difficult to
Then next day,
18th.
18, 21st, Tuesday.
use.
Unless nine.
Again, top of the list.
Madam. Number 2.
Mr. Soma, you have completed your part.
Yes.
Okay. Now, yes.
May I please, Your Lordship? In this case, actually, case is abated. This presently, Ananda Boro is alive, and Rita Boro and Sita Boro all are dead.
Who are alive now?
Ananda Boro, Rita Boro, and Sita Boro. And others are dead. Not a substitute in the petition.
Okay. Any other point?
No, I am not actually not at all a land defaulter.
You are not rent defaulter.
Not at all. There is. Your Honor. Here, rent receipt, there are so many rent receipt also.
No, the question is whether those documents were exhibited before the trial court.
The trial court of already executed.
Exhibited. Okay.
Already, there is a counterclaim also rejected. Short thing, that counterclaim also there. They filed a counterclaim, they are also rejected.
Okay. Any other point?
Rent defaulter was, no, where there are so many rent receipts. We are not at all rent defaulter. During the
Okay.
penalty period.
Okay.
And main question is here, now, how is the case is already admitted. Kaneshwari Boro also died on oral submission. There is no oral submission allowed. There is no any substitution petition is filed here in the records.
Okay. So your part is over?
Over.
Yes. Any reply?
My lord, your lordship kindly see the order dated 30/10/25.
13 of this court?
30.
Of this court?
Yes, yes.
13?
10/25.
Yes.
But the name of the my learned friend has submitted the so and so died. Their name was struck off from the
Okay.
memo of appeal.
Okay.
One died issueless and other their heirs are already on record.
Okay. Any other reply?
My lord,
Any other reply?
a reply is there, my lord.
Okay.
My lord, I have a decision of the Supreme Court, 3 judges bench. Yeah, my lord, the case is this, they have filed a suit that they may not be evicted forcefully from these premises. We filed a counterclaim that they are the tenant, they are defaulted, and they are liable to be evicted. That is purely under the Rent Control Act. Their suit was decreed when I preferred an appeal. In the appellate court make out a point which was not pleaded by the plaintiff, that
Mm.
the plaintiffs were protected under the Act of 1955, that is Assam Non-Agricultural Tenancy Act. That is not the case of the plaintiff, that they are the protected under this Act. And the learned, your lordship can see, the learned lower appellate court finding that they were protected. So for protection is concerned, there are some conditions. The land should be vacant. They have to construct within 5 years, permanent structure. Their splittings were not there. And another important thing is this: in their plaint also, they have stated that they deposited rent under the Rent Control Act.
Hmm.
Therefore, they are the tenant under the Assam Urban Areas Rent Control Act, and not the tenant under the Non-Agricultural Urban Areas Tenancy Act. And they have stated that they paid the rent in 2-3 months together. What is it? Play page 16. 60.
60 of this petition.
Yes. Paragraph number 11.
No, on the other day you have shown this paragraph to me.
Yes. Therefore, they are the tenant under the Rent Control Act, not under the Non-Agricultural Tenancy Act. Therefore, the findings arrived by the courts below is liable to be. And my lord, here in this judgment, Supreme Court judgment, the appellate court made out a new case for the
Parties.
for the plaintiffs. And the Supreme Court held the appellate cannot frame a new case for the other side. And the decree passed by the trial court was confirmed. The very short judgment, judgment passed by 3 judges bench.
Which is the relevant paragraph here?
Para 8. We have examined the plaint and we find paragraph 8 last part.
Okay. Okay.
Paragraph 8. Last. The decision cannot be based on the ground outside the plea of the parties. That the case is pleaded has to be found. The court therefore went wrong in ignoring the basic principle of law in making out a case and making out an entirely new case which were not pleaded and which were not the subject matter of the trial.
Heard. Mr. S. Sharma, learned senior counsel, assisted by Mr. Vardas, learned counsel for the petitioner, and Mr. Das, learned counsel for the respondent. Argument concluded, judgment reserved.
Hello.
For motion, item number 3.
May it please your lordship. The matter has become infructuous, so I may be allowed to withdraw this petition. Lordship.
Okay. Heard, Mr.
See, Kalita.
Learned counsel for the petitioner. The learned counsel for the petitioner submits that this matter become infructuous, and as such, he may be permitted to withdraw this petition. Fair allowed. This CRP instance dispose of on withdrawal.
Much obliged.
Numbers 4 and 5.
My lord, 5 will be taken up, my lord. This matter was in fact last time heard at length, my lord. But thereafter, my lord, this matter was fixed today.
Now,
Now this matter may be heard, my lord.
today. Oh,
Because they think that it may be fixed today, my lord. This is a matter, my lord, where, my lord, the truth itself is barred, my lord, on the face of it. My lord, in 78, Justice Krishna Iyer said, my lord, the bogus litigation should be nipped in the bud. There are, after, the series of decisions are there, on this point. I shall place, at least minimum 3 decisions I shall place only, on this point, where earlier judgments were also relied on. And first I shall place the plaintiff,
Mm.
Yes. The
Page number?
29, page number. Item 5, you will also take, no? Item 5 may be taken up,
5. Yes.
5, analogous.
Here page number?
Item 29, plaintiff starts.
Okay. Yes.
I shall start from para 10, page 38.
Yes.
That the plaintiff states that by virtue of the deed of dissolution dated so and so, besides other landed property, Schedule A and B property devolves in the share of Agarwala brothers who have acquired absolute right, title, interest over the Schedule A and B property, being partners of the farm of Assam Frontier, Veneer, thereafter. Therefore, all the plaintiffs and pro forma defendants have an undivided right, title, interest over the Schedule A and B property, which they have acquired not only by way of assignment of shares in the property through a deed of dissolution of the partnership, but also by right of inheritance and succession being the legal heirs of the late Krishna Agarwala. Now, para 12, my lord. The plaintiff states that after dissolution of the partnership concerned, the plaintiff number 1 and 2 and their deceased brothers, namely Radhesham Agarwala and Rajendra Prasad Agarwala, at regular intervals for some period of time, my lord, for some period of time, used to visit Tinsukia and Lidu in respect of their other business affairs. But with the passage of time, they winded up all the business with the Northeast region and permanently settled at West Bengal and started to grow up their business within the state of West Bengal and other parts of the country, due to which they had only some casual visits to Tinsukia, Assam. However, since last few years, nothing but last few years, no, all of them remained absent from visiting the Tinsukia, Assam, due to which plaintiffs were having no any up to that knowledge of the present status of the scheduled properties. That the plaintiff state that plaintiff remained absent from visiting Assam since a long period of time, and there was no any situation or reason for the plaintiffs to believe that any of the members of the Beria brothers or their legal heirs or any other person will do any adverse or hostile acts against the right and interest of plaintiffs over and in respect of the landed properties devolved in their respective shares. However, the plaintiffs in the month of July 24, through some reliable source, came to know that taking advantage of the long absence of the plaintiffs, a conspiracy has been hatched up by some of the members of the Beria brothers who are in illegal and unauthorized manner, without having any local right, title, interest over the scheduled property, negotiating for sale of the scheduled property with the prospective buyers. The plaintiff, upon getting the information about hatching the conspiracy for sale of the scheduled properties, made an inquiry into the matter and approached the defendant number 2 to furnish documents of the landed property devolved in the share of the plaintiff number 1 and 2, and the predecessor of the plaintiff number 3, 4, 5, 6, and the pro forma defendants, and also asked to furnish the information regarding the present status of the landed property devolved into a share. But defendant number 2 avoided to furnish any furnish or share any documents, information, so and so. Plaintiffs states that even though the properties were duly distributed among the partners of the firm, namely so and so, all the documents pertaining to a landed property devolved in the share of the plaintiff number 1 and 2, and their deceased brothers remained the office of partnership concerned at Lidu, which office was mainly looked after and managed by defendant number 2, due to which the plaintiffs were not accurately aware to the detailed particulars of the DAG, patta number of the scheduled property and B property, which have been changed after settlement of revenue records. The plaintiff states that thereafter plaintiffs through the different sources tried to find out the new DAG and patta number of the schedule A and B property, but plaintiffs unable to trace out the same. However, with the constant efforts of plaintiffs in the month of December 24, the plaintiff could be able to trace out particulars of landed property devolved in the share of, with full particulars which were standing in the name of their predecessor, namely Kesunam Agarwala, in the revenue record. That after much persuasion and efforts, made by the plaintiffs in the last part of month of December 24, through their engaged counsel, could obtain certified copies of the jobandi of the respective lands of Schedule A and B property developed in the share of plaintiff number 1 and 2, and their deceased brothers by virtue of the deceased deed of dissolution of the partnership entered amongst the partners of Agarwala brothers and Beria brothers. Plaintiff says that plaintiffs are not aware with the Assamese language as such. So the engaged counsel could come to know that entries in the appearing in the Jamabandi copies of Schedule A and B property, whereby the plaintiffs could come to know that taking advantage of the long absence of the plaintiffs and their state, Calcutta, West Bengal, the defendant number 1 to 5, in order to grab the scheduled properties under a joint conspiracy with each other in an illegal, unauthorized, and fraudulent manner, without having any local right, title, interest over the scheduled properties or any part thereof. So mutation case number 212 of 8182 and mutation case number 214 of 1882 and mutation case 216 of 1882, passed by the Circle Officer Margarita's Revenue Circle, District Assam, got the name of the defendant number 1 farm mutated in Schedule A, land measuring 2 bigha so and so, pertaining to periodic number. The land area measuring 1 bigha, 0 katha so and so, under dark number pertaining to so and so. Hello, I'm skipping over. Now, your losses, my lord, come to paragraph 19. The plaintiffs from the revenue record further came to know that defendant number 1 to 5 under a joint conspiracy with each other of the total Schedule A property, taking advantage of mutation entry of the defendant number 1 farm in the revenue record in respect of Schedule A land, claiming the defendant number 1 farm as owner of the land area measuring 2 bigha 4 katha 13 licha, covered by dark number 57 and periodic part number 15, to a deed of sale bearing number 350 of 2016, dated 12/9/16, sold out the said portion of the Schedule A land to the defendant number 3, who is also one of the partner of the defendant number 1 farm, and thereby in illegal, unauthorized, fraudulent manner alienated the said portion of the Schedule A land in favor of defendant number 3, which deed of sale is null, void, illegal, inoperative in law. Therefore, the same is liable to be cancelled by the dictatorial court. Yet the plaintiff states that defendant number 1 farm, being not acquired any right, title, interest over the Schedule A property or any part thereof, is having no any legal right or authority to execute the deed of sale any part or parcel of the suit property A in favor of defendant number 3. The said deed of sale being number illegal, unauthorized institution. Now, my lord, para 22, my lord. The plaintiff states that attorney of the plaintiff's father made an inquiry over the physical status of Schedule B property. Upon such inquiry, the plaintiff came to know that defendant number 4, upon getting the name mutated in the revenue record in a fraudulent manner, claiming himself as a lawful owner of the Schedule B property, rented out the Schedule B property to the defendant number 6 farm, whose farm is running a furniture shop over the Schedule B property. It is relevant to state that herein that the defendants and or other persons claiming under the defendants are having no any manner of right and authority to occupy the suit land. As such, the plaintiffs have filed the instant suit for eviction of defendants from the scheduled properties. As such, the defendant number 6 has been made a party in the suit for proper educational. So this is a suit for eviction. Now, my lord, your losses may come to para 24. The plaintiff states that the defendant number 1 to 5 in a fraudulent manner by forging documents got the name of the defendant number 1 farm mutated in respect of Schedule A. In the name of defendant number 4 has been mutated in respect of suit land Schedule B. Moreover, defendant number 1 and 5 committed criminal breach of trust with the plaintiffs. As such, defendant number 1 to 5 is required to be prosecuted for such criminal offences and all other offences as per law. And the plaintiffs are taking appropriate step for the same. Accordingly, plaintiffs kept the leave of the court to prosecute the defendant number 1 to 5 and all other persons associated with them for committing fraud, forging documents, criminal breach of trust, and all other offences. So and so. Now, the state the plaintiff had compelling circumstances, having no other alternative relief, instituted a suit for judgment and decree of declaration and cancellation of mutation others and shall deed recovery of possession of the suit land after evicting the defendants, their main agents, representative, and all other persons claiming under the defendants Schedule A and B, permanent injunction, so and so. Now 26, my lord, cause of action. The cause of action for the purpose of institution of a suit first arose on 1/7/74, being the date of execution of deed of dissolution of a partnership. In the year 1981-82, being the year get mutation order passed in the name of defendant number 1 farm over the respect of Schedule A property. 12/9/16, being the date of execution and registration of sale deed, being number so and so. On 26/8/17, being the date of mutation order passed in favor of defendant number 3. On 19/5/23, being the date of mutation order passed in favor of defendant number 4. In the month of July 24, being the month when the plaintiffs came to know about the hatching of conspiracy for sale of the scheduled property in the last part of month of December 24, being the month when the plaintiffs received the Jamabandi copies of the scheduled properties and came to know about the illegal mutual entry of the defendants in the revenue record and all such other dates when the defendants were instituted. Now, my lord, your office may come to the prayer portion at page 50. In the previous process so and so, A, judgment and decree declaring the plaintiffs and promotional defendants number 7 and 8 having undivided right, title, interest over the schedule, respect of schedule A and B land. Judgment and decree declaring that defendants are having no manner of any right, interest over the schedule and property. Judgment and decree declaring the defendants joint conspiracy with each other got the name of defendant number 1 farm mutated in revenue records of schedule B by mutation order number so and so. Mutation order so and so and so and so. Passed by circle officer, Margata Revenue Circle. Hence, the mutation are required to be can declare as null and void and illegal. Then judgment decree declaring the defendant number 1 without having lawful right, title and interest over schedule B properties have executed deed of sale in respect of sale deed bearing number 350 of 2016 in favor of defendant number 3 over respect of part of the schedule B land, which sale deed is void, illegal, so and so. A judgment decree declaring that defendant number 3 has not acquired any right, title, interest over the schedule B land property on the strength of the deed of sale bearing number so and so so and so. This is then next page 52. A judgment and decree declaring that defendant number 4 in an illegal unauthorized manner got his name mutated in the revenue record respect to schedule A land by mutation case number so and so of 19/5/23. Then judgment and decree
Let us see the impugn order.
my lord,
Impugn order.
impugn order, my lord, I'm just giving one. That is nothing, my lord, the cryptic order, page 125. The parties are duly represented. Today, date fixed for necessary order on the petition number so and so. Defendant numbers on order 7, rule 11, section 151 CPC. It appears that present petition has been filed on the ground that suit is barred by limitation that the point did not disclose the cause of action. Other learned counsel for both sides and peruse the petition and the filed by the defendants as well as written objection submitted by plaintiffs. Also peruse the plaint and other materials on the record. Defendants have contended that suit property originally belonged to partnership farm, some frontier veneer sawmill, and after dissolution of the said partnership farm by deed of dissolution dated 1/4/74, the properties were distributed among the two groups, namely Agarwal brothers and Vidya brothers. It further contended that the plaintiffs remained silent for more than 50 years, and the present suit has been instituted in the year 2024 after learning about the proposed sale of a property. According to defendants, the claim based on the deed of dissolution is clearly barred by law of limitation, and therefore plaintiff is liable to be rejected. On the other hand, plaintiffs have filed a written objection denying the statement of the inmate in the petition and have contended the suit disclose valid cause of action and involves a disputed question of fact, which is required to be adjudicated by evidence. The plaintiff OP relied upon the following directions, decisions of the Supreme Court, so and so and so. At this stage, it's pertinent to note that while deciding the application under Rule 11, the court is required to look into averments made in the plaint, not the defense taken by the defendant as held by the Honorable Supreme Court. It's correct. The Honorable Supreme Court in T, this is the case where Krishna has been given the judgment. Salim Bhai so and so held that power under Order 7 Rule 11 can be exercised only when the statements made in the plaint appears that the suit is barred by law or does not disclose any cause of action. In the present case, the perusal of the plaint cannot be concluded to be held at this stage that suit is barred by limitation. The question relatively deed of dissolution, nature of rights claimed by the plaintiff, and the alleged cause of action are matters which require education on evidence. Whether plaintiffs had knowledge of the alleged acts of defendants, whether the suit is within the limitation are mixed question of law and fact, which cannot be decided at the primary stage of merely on the basis of the application under Order 7, Rule 11. However, the plaintiff discloses certain assertions regarding plaintiff's right over the suit property and alleged acts of the defendants which primarily constitute a cause of action for filing the present suit. Therefore, the said plaintiff does not disclose cause of action, does not disclose cause of action within the meaning of Order 7. In view of the above, court opinion the grounds taken by the defendant for rejection of plaintiff require detailed examination during trial and cannot be decided at this stage. This is all. It not considered anything like that. Not considered.
No, you have taken the plea of limitation.
Yes.
Limitation is a mixed question of
No,
facts
madam.
and law.
No, my lord, I shall case, my lord, how it is a misconception of law. When, my lord, he himself admitted, he said that I am a trespasser. If you also see page, my lord, 53, earlier also, he said that I should be declared as trespasser over a property. And when they, my lord, went there, if we are trespasser, my lord, 12 years, only gone, my lord. How they can recover it? This is for eviction of the suit, my lord. Recovery of the property. I shall place the judgments of the Supreme Court, my lord, where Supreme Court says, my lord, that how it will be, my lord, if drafting, my lord, in the drafting, they say that this is cause of action, that will not do. Court has to see, my lord. I shall place the judgments, few judgments, my lord, I shall place before your lordships. First judgment, my lord, I shall place. Page 53, prayer may be seen, my lord. First. H and I. A judgment and decree declaring the defendants are trespassers over the Schedule A and B land and rendering the defendants liable to be evicted from A and B land with their belongings. Then, a judgment and decree for recovery of possession of Schedule A and B land by evicting the defendants, their main agents, representatives, and all other persons claiming under or through the defendants with all belongings vacant so into cast possession. My lord, your lawsuit, see, my lord, they have not come to since long, my lord, for last 50 years. Now they have filed this suit, my lord, and challenging the mutation of 81, 82 and salary of 16. I shall place the judgment, my lord. 74 dissolution deed. My lord, first I shall place very recent judgment to 2024-18 SCC, page 426.
No.
Hello?
Mr. Sahewala,
Yes.
you have to establish that the finding recorded by the learned trial court is illegal
No,
or arbitrary.
so that, my lord,
How?
that I have seen, my lord, I have shown from the plaintiff itself, my lord, that they themselves have said that for a long time they have not come.
Hmm.
And the mutation is of 81, 82, my lord,
Hmm.
and salary of
No,
2016.
maybe.
My lord, Supreme Court says, my lord, that if one person remain, my lord, sleep, my lord, and he said that I came to know about the salary only on such and such, that will not do. That is a judgment of Supreme Court, my lord.
Hmm. Hmm. So when the limitation start, according to you,
My lord,
when the limitation starts,
limitation.
yes, in
Well,
this case,
Since 74, my lord, that is the main way. They left, my
74.
lord.
74,
Yeah, they left Tinsukia, my lord.
74.
Deed of dissolution. They left Tinsukia. They started their business at Calcutta, my lord. They themselves said that for a few years they only came, thereafter they stopped. That is their statement. That is in paragraph 12, they said, after dissolution, for some period of time they used to visit Tinsukia only too. And thereafter they started their business. They wind up the business in the northeast and settled in West Bengal. Registered deed of dissolution is in Calcutta, my lord. Because they were from the earlier time, point of time they were in there. And that is why, my lord, the registered deed of dissolution was executed in Kolkata, my lord. That is in page 35. Page 35, my lord, if you also see, the deed of dissolution was executed in Kolkata, 1st day of April 1974.
Yes.
Yes. Now, my lord, if you also see, my lord, this judgment of,
So what is the period of limitation here?
my lord,
What is the period of limitation here?
limitation, my lord, we are, if we are trespassers, my lord, they say, themselves say, 12 years, my lord,
12 years.
12 years maximum,
Okay.
not more than that.
Okay. So this is only the law point you are relying on.
Yes, my lord, I shall play.
Limitation.
Yes, now, this 2418 SCC 426, my lord,
Hmm.
I've given that. Your losses may take up the para 9.1, but, my lord, at page 429. You also got it, my lord?
Yes.
Yes.
Para number?
9.1, my lord.
Yes.
This is also application under order 7 to 11. It is submitted that as such the suit is clearly barred by limitation, therefore the plaintiff ought to have been rejected under so and so. It is further submitted the High Court has not properly appreciated of the fact that in fact the suit was barred by limitation as the same was instituted 61 years after the execution of the partition deed, that is so and so. Then my lord, your losses may come to paragraph 19 to 20. 18, my lord. 18. At page 433.
Hmm.
Your lordship got it, my lord?
Yes.
Yes. In Mansuri number so and so, my lord, that is the case of 2017. The plaint can be rejected under Order 7 Rule 11 if the conditions enumerated in the said provision are fulfilled. It is needless to observe that the power under Order 7 Rule 11 CPC can be exercised by the court at any stage of the suit. The relevant facts which need to be looked into for deciding the application are averments made the plaint only. If on the entire and meaningful reading of the plaint, my lord, this is the meaningful reading of the plaint, it is found that the suit is manifestly vexatious, meritless in the sense of not disclosing any right to sue. The court should exercise the power under Order 7 Rule 11. Since the power conferred on the court to terminate the civil action at the threshold is drastic, the condition in Order 7 Rule 11 to exercise of the power of rejection of the plaint has to be strictly adhered to. The averments of the plaint have to be read as a whole to find out whether averments disclose a cause of action or whether suit is barred by law. It is needless to observe that the question as to whether the suit is barred by any law would always depend upon the facts and circumstances of each case. The averments in the written statement as well as contention of the defendant are wholly immaterial while considering the prayer for rejection of the plaint. Even when the allegations made in the plaint are taken to be correct as a whole on the face value, if they are so that suit is barred by law, in law, or do not disclose in construction, the application for rejection of the plaint can be entertained and the power under Order 7 Rule 11 can be exercised. If clever drafting of the plaint, this is important matter. If clever drafting of the plaint has created an illusion of a cause of action, the court will nip in the bud at the earliest, so the bogus litigation will end at the earliest stage. In Ram Singh versus so and so, this court observed and held that when a suit is barred by any law, the plaintiff cannot be allowed to circumvent any that provision by means of clever drafting so as to avoid the mention of those circumstances. Well, they have not said, my lord, when we have trespasser, when we have entered there. After 74, my lord, they say only a few years we came, they are settled. Nothing mentioned, my lord. This is a clever drafting, my lord. Similar view is taken by the court in Rajnaran Singh. Applying the law laid down by his court in the aforesaid decision on the applicability of Order 7 Rule 11, the facts of the case, we are of the opinion that plaintiff ought to have been rejected in exercise of power under Order 7 Rule 11 A and B of the being vexatious, illusory cause of action and barred by limitation. By clever drafting and not asking any relief in respect of with respect to partition debtors, so the plaintiff have tried to circumvent the provision of Limitation Act and have tried to maintain the suit in which is nothing but an abuse of possession of the court. Now, so far the reliance placed by the decision of the Privy Council referred to here above and the decision of this court in Subhaga are concerned, there cannot be any dispute with respect to the proposition of law laid down the aforesaid two decision. However, the question of is the suit is being barred by limitation and the illusory cause of action. Now, so far the reliance placed upon the decision of this court in so and so is concerned, again, there cannot be any dispute with respect to the proposition of law laid down by this court that while deciding the application under Order 7 Rule 11, mainly the averments the plaintiff only are required to be considered and not the averments the returns. However, on considering the averments of the plaintiff, if there would our opinion that the plaintiff ought to have been rejected being vexatious, illusory, cause of action and barred by limitation is clear and is a clear case of clever drafting. In view of the above, for the reasons stated, the impugned judgment and order passed by the High Court and that of the trial court rejecting the application under Order 7 Rule 11 are unsustainable and the same deserve to be quashed and set aside and are accordingly quashed set aside. Consequently, the application submitted by the appellant original under so and so exercise of power under is hereby allowed and consequently plaintiff is ordered to be rejected. Now, my lord, I shall place the judgment of my lord 2020 16 SCC page 60.
This is on the same point.
My lord, no, I shall place my lord, some of the my lord, very important some my positions are there. My lord. If you also see paragraph 6.7, 8, 9, then 7, 9, 10. 6 paragraph. 6.7, my lord. At page 609.
Hmm.
In ITC, you also got it, my lord?
Hmm.
In ITC versus so and so, it was held that basic question to be decided while dealing with an application filed under Order 7 Rule 11 of the Code is whether a real cause of action has been set out in the plaint or something purely illusory has been stated the view to get out of Order 7 Rule 11 of the Code. The trial court must remember that if on a meaningful and not a formal reading of the plaint, it is manifestly vexatious and meritless in the sense of not disclosing a clear right to sue, it should exercise the power under Order 7 Rule 11 of the Code, taking care to see that the ground mentioned therein is fulfilled. If a clever drafting has created an illusion of a cause of action, it has to be nipped in the bud at the first hearings by examining the party starting under Order 10 of the Code. In modern so and so. The plaint can be rejected under Order 7 Rule 11 if the conditions unified to the said provision are fulfilled. It is needless to observe that the power under Order 7 Rule 11 can be exercised by the court at any stage of the suit. The 11 facts which need not be looked into. Well, I am speaking about this one. Now 6.9. In Ramsing, this court observed and held that the suit is barred by law. The plaintiff cannot be allowed to circumvent that provision by means of clever drafting so as to avoid mention of those circumstances by which the suit is barred by law of limitation. Then para 7. Applying the law laid down by this court in aforesaid decisions on excessive power under Order 7 Rule 11, the facts of the case in hand and averments in the plaint, we are of the opinion that both courts below have materially erred in not rejecting the plaint in excessive power under Order 7 Rule 11. It is required to be noted that it is not in dispute that a gift deed was executed by the original plaintiff himself along with his brother. The deed of gift was registered gift deed. The execution of the gift deed is not disputed by the plaintiff. In the case of a plaintiff, that gift deed was a sole deed of gift and thereafter the same is not binding on him. However, it is required to be noted that approximately 22 years, neither the plaintiff nor his brother, who died on so and so, claimed at any point of time that the gift deed was a sole deed of gift one of the executors of the gift deed, brother of the plaintiff during lifetime, never claimed that the gift deed was a soi gift deed. It was appellant herein, the original defendant who filed the suit in the year 2001 for partition, and the said suit was filed against his brothers, to which the plaintiff was joined as defendant number 10. It appears that the summon of the suit filed so and so.
Okay, all right.
Yes, my lord. Now, there are 9, my lord, your lordship may just see, my lord, there is the same, 9 and 10. Now I shall place another decision, that is a main decision,
On
my
the
lord.
same point,
My lord.
on the same
Yes,
point.
here, my lord, many cases are considered. Yes, your lordship. This is,
Okay,
my
no,
lord,
no, no, not necessary
This
to
is the
multiply the
important-
decision,
My lord?
not necessary.
no, just a few paragraphs, my
No,
lord.
no, no, not necessary.
Your lordship may just see, my
Same point, it is not
lord.
necessary. Anyway, I will examine it, hand it over to the court master.
My lord,
Okay.
yes. Left hand word. No, no, हाँ, बस ठीक है, अच्छा है कभी। रुको, रुको। कहाँ गया? ये है, 24, 28.
So
मतलब
your part
paragraphs,
is over?
I shall mention the paragraphs, my lord.
Okay.
Here.
Your part is over?
Yes, my lord, this is the.
Yes.
My lord, here, you have also seen, my lord, that we are held with trespassers, my lord,
Mm,
and they paid for recovery of poison, my lord,
mm.
declaring all the mutation and shall discharge null and void, my lord. Yes, my lord.
Yes.
I'm paying for the plaintiff. I'm paying for the plaintiff.
Yes.
But here, the primary ground
Mm,
as it is reflected in the trial court order as well as the submission made herein
mm,
is that this said that the deed of resolution of 1974
mm,
was of 1974 and there is a it is barred by limitation.
mm.
Got it? Also, it has been urged by the London senior that it is the averments made in the plane which has to be looked into it. There is
Yes.
no debate and dispute about the fact it's only the averments which are.
Yes,
Mm,
yes.
mm,
There is no, that for that I do not. There is no counter laws. That's an admitted fact.
mm.
No logic. Here, the initial point was that has been said that there is a clever drafting. Here is a case of clever reading of the plate. They
Mm.
have not read the whole plate.
Mm.
Lordship may come to page 39 for a moment. This is the part of the plate.
Mm.
Paragraph 10 was read. Paragraph 11 was left out.
Mm.
May I read for a moment?
Mm.
That the plaintiff states that after dissolution of the partnership concern, the Agarwala brothers and the Beria brothers have distributed their respective share of capital in the said partnership concern amongst themselves as per the terms of the dissolution, and there was no any hostile claim and or objection against the execution of the dissolution of deed of dissolution, its implication and compliances by any of the members of the Agarwala brothers and Beria brothers. Moreover, the terms of the terms and conditions of the deed of dissolution of the partnership has been duly acted upon by the Agarwala brothers and Beria brothers. Therefore, said dissolution of partnership remains undisputed and unchallenged since last 50 years. What is the dispute about? There was a property in the partnership firm. Agarwala brothers were there, Beria brothers was there. They got their property, Agarwala brothers got their property, Beria brothers got their property. Now what had happened is that the property that was being interested, the area was looking, there was no dispute about hostile claim. We said in July 24, we have come to know about it. That is a disputed question. They will prosecute and say how you came, what was it? Are we challenging the terms and conditions of the deed of dissolution? There is a clear averment saying that we are not challenging, we are not on the deed of dissolution that it was wrong, it was wrongly implemented, it was wrongly done. We are not saying that thing. What has been projected, tried to be projected in order 7 petition is that the dissolution happened, you did not come. So whatever is it, that means it is the dissolution which you are trying to agitate in the prayers, the trespassers and all. The learned trial court rightly exercised, has rightly had come to the finding that it is a mixed question of law and facts. We said we have come to know in July 24. We said that these are the circumstances. This subsequent paragraph which has been read. I'm not reading again. The paragraph 11 I read. Then again paragraph 21 and 23 has to be read. Here, what had happened is that amongst their family members, they executed a sale deed. It is It is not that the sale deed was executed to some third party. Illegal. That's what we are contending. It's an illegal sale. So these will be all matters of trial and evidence. And order 7, rule 11 petition, the boundaries are limited. A to F. That's the thing. These are the only things which you can do. And only under, if any of the claim falls under those provisions of A, B, C, D, E, F, then only a order 7, rule 11 petition will be entertained. Here they are saying it is limitation. Why limitation? 1974. On my bare perusal of the claim, wherever I challenge, the prayers are not saying that the 74 deed of resolution is wrong. We say the actions subsequent to the deed of resolution. These are the actions that have been put to test. That is my contention regarding the limitation part. There are ships. There is a
Yes.
the claim in all the paragraphs that you read. Again, I'll not read the whole paragraph. It will not serve any purpose. Here, the last mutation order is of 23. It is the challenge. Schedule. The challenge is of my prayer is F. F prayer I have said. Page 52 is the prayer where I have challenged the last mutation order. A judgment and decree by declaring the defendant number 4 in an illegal and unauthorized manner got his name mutated in the revenue record in respect of Schedule A land by mutation case number such and such dated 19/5/23. When these things happened, that only I came to know, and these are the records. Then only I came to know about these things, and that's why I filed a suit. The other prayers are there where there's a sale deed of 2016. I am not aware of a sale deed because I was under the bona fide impression that the property has been taken care of by the various brothers. Now, had this sale, assuming that they had sold this property to some other party, and I was like sleeping over, and that also would have been a case of different aspect. But it is within the family. Defendant number 1 and 3 are within the family. So that being the part. So within the family, they have executed a sale deed. How will I know? If it had been third party or some party, if the third party would have taken over the property, they would have constructed, then I have seen. So these aspects are to be examined through evidence. Whether at this stage, where under Order 7, Rule 11 petition, the trial court would have formed an opinion, yes, it is barred by limitation. I ask myself this question. Based on the evidence that I have made on the evidence made on the made in the plane. So that was the clear finding, and the clear it is a short, precise, to the point order, in my respectful submission. Thereafter, they have also in their counterclaim admitted to the two. They have admitted to the distribution property, which I have already stated about, the 1974. Yes, Tinsukia property is a property in Tinsukia, there is a property in Lido. So Tinsukia property, they have admitted to the fact, but the Lido property, now when the distribution is there, we have said we have got Schedule A property as well as Schedule B property. They have admitted to the Schedule B property, yes, they have got it. Now, whether Schedule C property has been, whether it should be to us or not, again, will be a matter of trial. Logic. This faced with all the trial, my respectable submission is that the claim discloses prima facie the cause of action. It is filed within limitation, and the order passed by the learned trial court suffers from no infirmity because it has been a very specific cryptic order, not cryptic, specific clear order saying that it is a mixed question of fact and law. What you had placed only 3 judgments on 3 different points. First point is the point as to where the when the knowledge of adverse position comes to effect, when it is to be taken into account. That's first point. Second point, Lordship, I will
No, no, whether such plea is taken in this case, whether the plea of adverse position is taken in this case,
they have taken.
they have. Okay.
In the counterclaim, they have claimed that we have.
They have themselves said malady adverse. The
That
pair
is-
also.
if they are
said.
test- we have
They are
said
also
we
they
are
have said.
We are saying test person, they are saying adverse. That I claim will come
Same thing.
at any point of
Same
evidence. They
thing.
will be
Same
at
thing.
this stage.
Same thing.
Now we are not deciding who has the better right. Second, the period of litigation. Second one is a mixed question of fact and law. It has to be an order 7 petition cannot be adjudicated. And the third judgment, what I give the paragraphs as well. The third judgment talks about a claim cannot be rejected in part. Specific finding. Assuming without admitting, they are saying that we are trespassers, they have knowledge, it is barred by limitation or what. Assuming without admitting, which we are not admitting, we are saying we only came to know in 24, it cannot be rejected in part. That's the law.
No, no, that is not their pair also.
They are saying we have prayer F, they are saying we are trespassers, that means it is barred by limitation. They are saying they have.
No, no, their
pointing out a
contention
specific
is that you have pleaded in your plaint that they are trespasser. But when they have trespassed into the property, that has not been mentioned.
No, we have come to know in July 24. So when for the point as to when they have we are not the category of trespassers was not, because we were under the impression that the whole property was being taken care by them, and we were going there. They have given the sale deed, they have done all these things. Now these things will be taken in evidence. If we are not able to prove that the point as to when the date of trespassing was there, then it will be executed at that relevant point of time, whether at this stage.
No, no. They have taken the plea of trespasser to substantiate their plea of limitation.
That's now that I have a prayer, there are 15 prayers.
Hmm.
Assuming that prayer for the point of limitation, again, that is to be adjudicated. Assuming that prayer has to be adjudicated now, whether what was the exact point when we trespassed and what were the limitation when we have started as lordship had taken as 74 and 15 years, if that has to be taken into account, then it's only a particular part of the claim which should be there in law. Assuming for a moment. This is the judgment which says that a claim cannot be rejected in part.
Mm.
This is where I'm assuming. I'm not saying the factum that the declaration of trespassers has to be that declaration, whether it will be right or wrong declaration, but what assuming for a moment. If that is barred by assuming for a moment, it cannot be rejected in part. This is my submission. This is what the judgment says. May I show the reference?
Yeah, hand it over to the court master.
I have mentioned the paragraph also. But you may read or
Not necessary. You hand it over to the court master.
My submission would be that the order, again, to be produce the order from the London trial court.
Mm.
it suffers from no infirmity. The grounds that have their ground of limitation, it is not a question where they have rejected that there was no limitation. What the trial court has said, in the present case, from the perusal of plain, it cannot be conclusively held at this stage that the suit is barred from liquidation. When that appeal, the plain that has the revision petition has been filed, that has not a single pleading which says that it conclusively proved. It is prima facie proved. Yes, this is the date and this is the limitation. It is not a case where it is just one. It's not a case where a particular deed is there. I had to receive the money within 3 years, and I did not file a case within 3 years, and that's why it is conclusively. That is a conclusive proof. When it cannot be conclusively proved, when I'm saying in July, it is, I have come to know, 23 days of mutation order. Mutation order regarding that same property of Schedule A. If the court comes to the finding that Schedule A property it belongs to the Agarwal brothers, then all other things that had happened subsequent after 74 dissolution will be bad in law. If the court comes to the finding that the 19.523 order, mutation order is bad in law, then the prior part of 81, the 2016 deed, those also will be bad in law. It cannot be that after the dissolution was done and that property which went to the Agarwal brothers, and the court comes to the finding that yes, it is the Agarwal brothers who owns this property, that will have an effect. So that is the limitation part cannot be bifurcated for one part, only one prayer and the other prayer. That's my humble comment.
My lord, one point, my lord, I'm sorry. My lord, so far said it is concerned, my lord. In fact, those two judgments does not say, my lord. The earlier judgments were referred to in the subsequent another case, my lord, where it says in para 33, my lord. Whenever a document is registered, the date of registration becomes the date of deemed knowledge. In other cases where a fact would not be discovered by due diligence, then the deemed knowledge would be attributed to the plaintiff because a party cannot be allowed to extend the period of limitation by merely claiming that he had no knowledge. So for salary is concerned, my lord. Second 34 para. Section 55(1) of the transfer property regulates the rights and refer to a judgment wherein the effect of willful abstention from making inquiries was laid down, and the following paragraphs are relevant. My lord, these paragraphs are mentioned, my lord. Para 34. Then, my lord, so far, para 36, my lord, another aspect of the matter is considered here. I shall just listen. Further, the aforesaid suit, respondent number 1 sought possession of the suit properties based on title. As per Article 65 Limitation Act, possession of movable property or any interest therein based on title can be sought within 12 years, my lord. This is again, my lord, reiterated here. In para 36. This judgment is very important, my lord. Some paragraphs are there. You'll also, my lord, consider. This is also latest judgment 24/15 SCC 675.
Okay.
My lord.
So what about this CRP IO number 257 of
Same, my lord. Same. For the same, my lord, here. Same order.
How both are same?
Both are same, my lord. One other party has challenged that order. Same, my lord.
Okay.
Who is the tenant?
Tenant also filed the order 7. They also filed an order 7.
Okay.
Same.
Order.
Heard Mr. Sayola, learned senior counsel assisted by Ms. Cody, learned counsel for the petitioner, and Mr. Das for the respondent. Argument concluded, order is out. Caveat will be heard, caveat is then discussed. 2 caveats are there.
Number 6. May it please your lordship. Lordship, the matter may be adjourned for the day, as there's some personal difficulty in conducting the case. We need some time.
Okay.
If possible, lordship may accommodate this case on in the last week of July or first week of August, if possible, lordship.
Okay. As agreed by learned advocates of both the parties, recess unless the matter. Covered.
Court
4th of August.
Deeply obliged.
Therefore, orders item 7.
May I please your lordship. Lordship, may kindly peruse the office note dated 9/7/26, my lord. It appears that the
So we'll wait for the service report of process server? Or you want to take fresh step?
well, I will take fresh step by way
Fresh
of
step.
speed post move.
Speed post?
Yes, ma'am.
Okay, heard Mr. NDP Sinha, learned counsel for the petitioner. Office note dated 9/7/2026 indicates that neither ready card nor unserved notice issued to the respondent returned till date. And the said office note also indicates that consignment tracking details were also not available at the website of the India Post. Further, said office note also indicates that process service report has not been received for the respondents till date. Learned counsel for the petitioner submits that he may be allowed to take fresh step upon the respondent by speed post. We are allowed step be taken within a period of 2 working days from today, less after 4 weeks.
May I pray for a date, my lord?
Date.
On 19th August,
Obliged.
item number 8.
May I please, Your Lordship?
Yes.
In this case, the respondent have filed their affidavit in opposition, we need to file a reply on. Lordship. So we need to.
Mr. Counsel, you say this is not a writ petition. This is a CRP against IO.
Lordship. What I have been instructed is to.
Hmm?
I have been instructed this one, that we will file a reply. Some.
Here we are only examining the impugn order, whether it is a correct or legal or illegal.
Yes.
So what is there, it is already there. Your any affidavit in reply or counter affidavit, it will not improve your case. Mr. Nandi?
My lord, your lordship is on the point of law, your honor, your lordship is.
So what to do then? We'll fix the matter for admission hearing.
For admission hearing, little bit.
Lordship.
Date.
Date.
Yeah, in the meantime, if you want to file, you
Look,
file it,
look.
but I don't think it will help you because we cannot take any other consideration except the order, impugn order.
Some points has been raised, we need to clarify those points, that is necessary.
Heard, Mr. Your name, please?
FM.
Learned counsel for the petitioner and Mr. Nandi for the respondent number, for the respondent,
And for all the respondents.
for all the respondents. Since service in this matter has already been completed, SSL is the matter for admission hearing. In the meantime, learned counsel for the petitioner may file his objection, the reply to the objection, if so advised. List on. Correct.
On 13th,
This is okay.
items for hearing, item number 9, pardon me.
Here before my learned friend starts.
Pardon?
Here before my learned friend starts. Here, lordship in this matter, Vinay Prasad, who is respondent number 2. He is expired
When?
2 years back. And I've gone through the,
Mr. Talukdar, what to do?
just now I've received the information. And the whole order is against Vinay Prasad.
then he may be, the.
One way is there, we may strike up his name from this
To be,
appeal,
to be inserted, my lord.
required to be inserted,
Substituted.
to be substituted.
Otherwise, there is lapse.
So policy was not valid.
No, Lordship.
Policy is valid.
Yeah, for driving license was fact, that is why.
Okay.
That is why entire liability was given to the owner of the vehicle. So they have to substitute the name, the legal.
Okay, okay. Heard Mr. Talukdar, learned counsel for the appellant, Mr. Mohanto for the respondent number 2, respondent number 2, and Mr. Mr. Bhatt for the respondent number 1.
Yes.
And 3, who is for 3? The driver?
Three is the driver. He's the driver. Driver.
Yes. Service completed in respect of the driver?
Completed.
Completed. Okay. Mr. Mohanto submits that respondent number 2, the owner of the vehicle, suffered demise about 2 years back. And as such, there is a requirement of implementing the legal heirs of the respondent number 2. Mr. Talukdar submits that he may be granted some time to file a relevant application for bringing on record the legal heirs of the respondent number 2. They are allowed to list the matter after 2 weeks.
But while at 4 weeks time is maybe.
4 weeks.
Hmm.
Okay, 4 weeks.
Item 11.
Lordship heard this matter earlier, Lordship. I am against an order of the learned Railway Claims Tribunal, Lordship. And therein, Lordship, before the Railway Claims Tribunal, Lordship, I prayed that the railway imposed a penal demurrage upon me, Lordship. So they imposed that without following the procedure mandated under the corrigendum, which is relevant. And that was put to challenge before the Railway Claims Tribunal, and that was rejected, Lordship. And subsequently, I filed a review, and in the review also that was rejected. So against that order, I came before your Lordship. Now, that rejection order, Lordship, it's at page 70, Lordship.
Mr. Sharma, wait for some time. They will inform the council.
Lordship.
CGC.
Yes, Lordship. I talked to him a few minutes back, Lordship. He said he will come. And that's
Okay.
why.
Okay.
Let him
You
come.
will inform him.
I
If possible.
informed him already. I'll call him again.
Okay.
Lord.
Number 13.
Lordship,
Hmm.
I'm on behalf of SP Chaudhary for respondent number 1 to 5 and 7.
None appears for the appellant on call. However, Miss
Didas,
learned counsel for the respondent number 1,
1 to 5 and 7.
1, 2, 5, and 7 present. List the matter after a week. In the event of subsequent non-representation of the appellant, appropriate order shall follow. Ah.
So come to 23rd July. Item 14.
You are for the respondent. Appellants are absent. None appears for the appellant on call. However, Miss, your name, please.
Deep Sharma.
B. Sharma, learned counsel for the respondent, for all the respondents? For,
Two respondents.
for both the respondents present. List the matter after a week. On, Kabir,
My lord, after 4 weeks.
4 weeks. This is old matter, 2015 matter.
4 weeks.
18 August. In the event of subsequent non-representation of the appellant, appropriate order shall follow.
Item 15. 15.
Please, Your Honor.
You are for the petitioner.
Yes, Your Honor.
Other side is absent.
Yes, Lordship.
Heard, Mr.
A. Mohammed.
Learned counsel for the petitioner present, none appears for the respondent on call. List the matter after a week.
Lordship, a date may be fixed.
Correct.
28 July.
Obliged.
Item 16.
You are for the
Respondent number 1.
respondent number 1. Appellant? Absent today.
I have seen him. Some people.
You have seen?
Yeah. So, my head is-
So wait for some time.
Coming item 11.
Possible has already heard, I was only required to provide a judgment in regard to whether notice is required or not before this thing, before penal charges, penal demerit charges. Because as per his submission, it is compulsory. What the apex court has held, Lordship, let me kindly see the problem. The issue is this, Lordship. Because thing was that in the pleadings, it has been mentioned that only a telephone call has been given. Telephone call has, the intimation through a telephone call is given. And there was no access notice. And we have this thing that penal charge was been levied upon them. So the judgment says, that para number 11. This is not enough in the person mega technical. But alternative rhythm division. In the very nature of things on raising such a demand when excess weightage has been detected at the time of offloading, it would be practically difficult, if not possible, for the appellant railway to issue a show cause notice to the consignor or consignee and to hold a mini trial to determine the question of excess weightage and consequential levy of compensatory charges. And following process, nevertheless, the appellant railways need to be updated and upgrade themselves with the advancement of technology. Yes, there is no gainsay that the mechanism like automatic videography of the loaded weight along with the weight measurement at the time of offloading can save the parties from easily avoiding litigation. In the event of consumer dispute, the liability towards charges for excess weightage such electronic collected proof can be supplied to redress the grievance. We are quite sure that by now, railway must have introduced some effective scientific method to meet with such challenges. However, we have observed that it's only on an illustrative basis to suggest that we hope that trust that with a view to incentivize its consumers and customers, the railway continue to upgrade regularly. As science has gone far ahead, and given the presence of time, we find that improved judgment is now obsolete, redundant, the same is accordingly set aside. the appeal is disposed of in light of the observation made herein above. So. If an aggrieved person is disabled, the court has in the cited decision permitted them to approach the railway dates tribunal. The alternative FSS remedy is always available to such person. This is basically the judgment, Lordship.
Oh, this is the judgment, but what is the requirement of law? What is provided in the act?
Lordship, in regard to the act, Lordship, there is one circular. Yesterday I was going to, I don't have the hard copy of that. We say there's some, as part of the government circular, notice is required, I'm saying. And all, but this is basically, this is a precedent also. And that circular I have gone through, which says, Lordship, before leaving of penal charges, one notice is required to be given. Some 3.4.
No, that notification is still holding the field.
Is still holding the field until this judgment has interfered. But this judgment interfered in regard to this area of law, Lordship. So,
As per my understanding, Lordship, these judgments only speaks about excess weight, Lordship.
no.
And-
I think you should have gone through the judgment. Can't go through the judgment.
Can you produce that hard copy of that judgment?
Lordship,
No, sorry, that notification.
Lordship, I'll try to get it, Lordship, because yesterday evening I was going through it.
If you have the soft copy, you can forward it to the court master. We can take a printout from the computer.
Lordship, may kindly turn to paragraph 6 of this judgment, Lordship.
Yes.
In a way, the subsequent events rendered these proceedings infractious and academic. However, learned counsel for the railway, appellant railway submits that there are conflicting views taken by the High Court on the issue as to whether in case of excess weightage, the railway is obliged to issue a so-cause notice before levying the penal freight for such excess weight. So here the question is with regard to levy of penal freight, Lordship. Not penal demurrage, Lordship.
No.
So there is a difference between penal freight and penal demurrage. How? The definition itself says, Lordship. The Lordship will kindly peruse the Railway Act, Lordship.
Okay.
Railway Act section 2, subclause 11 says about demurrage. Demurrage means, has your Lordship got it?
Got it.
Demurrage means the charge levied for the detention of any rolling stock after the expiry of free time, if any, allowed for such detention. And section 2, subclause 17 says about freight. Freight means the charge levied for the carriage of goods, including transshipment charges, if any. So those two are different things, Lordship. Demurrage is different and freight is different, Lordship.
In your case, it is demurrage.
Yes, Lordship. In my case, it's
In
demurrage.
respect of demurrage, there is a requirement of issuing one notice to you.
Yes, Lordship. That is at page 72 of the Lordship appeal, MFA.
Okay.
The requirement,
that notification is not on
yes,
the record.
It's on record, Lordship.
On record. Okay. Page number?
Page 72. Annexure 9. Lordship, 3.0 simply says about the rates of demurrage charge. And 3.4, it says about penal demurrage charge.
Hmm.
3.4.1. In case excess congestion takes place at any terminal / steel plant, PCCM, PCOM, DRM can increase the demurrage rates even at progressively increasing rate, subject to maximum of 6 times of the prevalent base rate. The penal demurrage rates should be implemented only after giving wide publicity, including through SMS/email, and due notice at terminal of 24 hours, and should be applicable for the notified period. Now, 3.4.2, the rates can be increased by say 2 times or 3 times or so on, and not necessarily 6 times at one go in all cases. In fact, railway may decide to levy variable rates like 2 times for first 3 hours detention, 3 times for next 12 hours detention, and so on and so forth. Railway must judiciously evaluate the situation, and rates should be increased on merit to the extent considered justified. Levy of 6 times rate should be resorted only when the situation becomes very alarming. Modalities for implementation of penal demurrage charge are given below for compliance. Number A, issue of notice for imposition of penal demurrage and imposition of penal demurrage may be treated as 2 separate activities. Number B, notice period for imposition of penal demurrage, which is for duration of 48 hours at present, may be reduced to 24 hours. Number C, notice for imposition of penal demurrage may be issued via numbered control message of commercial control with the verbal approval of the competent authority PCCM, PCOM, DRM. Number D, immediate intimation of the notice for imposition of penal demurrage shall be sent automatically via system generated SMS and email to all the concerned customers as per the goods shed profile. And number E, imposition of penal demurrage 24 hours after the issue of notice as mentioned in the above subpara shall be with formal approval of the competent authority. In this case, Lordship, there was no notice, and in the OA filed before the tribunal, they simply said that Lordship, it was informed over phone. That
Lordship, one thing.
No, Mr. Borra, let him complete.
Lordship, that is at page 35. Page 35, Lordship, this is what they relied upon to say that it was informed over telephone, Lordship.
35.
35, Lordship.
Okay, all right. So, according to you, this judgment will not assist him.
No, Lordship.
Okay.
On the last
Since it relates to penal weight,
freight, yes, Lordship.
penal freight, penal freight.
On the
Okay.
last occasion, I gave a judgment, Lordship.
This
not,
one,
Not this one, Lordship.
separate one.
It's of a division
Yes,
bench.
yes, it is available on the record.
It's of a division bench of the Allahabad High Court that deals with the issue, Lordship. Just for reference,
Paragraph number?
Lordship,
There is no paragraph number.
short judgment, Lordship. Paragraph in page 3 from the bottom, the second one, it starts, Lordship, the relevant portion.
Okay. No notice has been given in terms of paragraph number 3.3.
No, Lordship. It was not given. It was not given. In fact, Lordship, what had happened, Lordship, they collected the charge as demurrage charge only. It was not collected as penal demurrage, Lordship. In the money receipt and all, it has been shown only as demurrage charge, Lordship. And later on, Lordship, in their written statement, they disclosed that, Lordship, it was not demurrage, but it was penal demurrage, Lordship. So my prayer initially was with regard to demurrage only. And subsequently, when it came to notice that it is penal demurrage, then in the rejoinder, Lordship, I specifically stated that you cannot do that, Lordship, without following the procedure. Since the procedure, it says that there has to be a notice, and apparently no notice was served upon me.
Okay. Yes, Mr. Borwa, what is your point?
I want to put some light on the point, Lordship. My friend want to distinguish it is not a penal and demerit charge.
Mm.
It is freight.
Mm.
But in regard to the order that I got just now for the court.
Mm.
Para number 3.
Mm.
The instant controversy arose on so and so. When the respondent booked a rail consignment of dry fly ash with the apparent railway at Duliaganga railway station, the consignment was reweighed and the finding that there was an excess weight demand notice of 10 lakhs. Here in the case, it is only of 2 lakhs. Was issued as penal fine for excessive weightage and rupees 43,000 as demerits. Seeking to question and to obtain a stay on the same, the aggrieved respondent filed its petition so and so. The High Court called upon the appellant to explain why the demand notices are not to be quashed. However, the High Court did not grant interim stay to the demand notice agreed by the so and so. In terms of the respondent filed it appeal to set aside the same and issued necessary direction to restrain the appellant for invoking the corresponding bank guarantee. Lordship, what I want to say, Lordship, instead of becoming Lordship, whether it is freight, whether it is penal, emergency, we have to see what the Supreme Court, the spirit of the judgment, Lordship. We have to see what the Supreme Court want to say, Lordship.
No, that's all right, but both are differently defined in the act itself. Penal demurrage.
When basically,
And-
Lordship, in one of our reply, we have mentioned that when such a situation arises, Lordship, the whole this thing is being reoccupied. There is a jam in, and Supreme Court has already considered it, Lordship, that it is not something practically possible to give a notice and you apply the charge bill because the situation was of a urgent nature, Lordship.
No, that's all right, but you cannot argue against your own notification.
Because
It is your notification which he has relied upon. Now you cannot argue against your own notification. Anyway, we will examine the matter.
relying what the apex court has hold, Lordship.
Okay,
Because,
all right.
So the apex court is above all, Lordship. That is the
No, may not be because act is already there.
highly up to your Lordship.
Heard Mr. M.T. Sharma, learned counsel for the appellant, Mr. Borua, learned CJC for the respondent, argument concluded, order reserved. We'll resume after 5 minutes.
Item 13, my lord, I narrowly missed, my lord. Lordship has fixed a date, my lord. Item
Okay,
13.
you take it that from me.
Only just my name maybe.
Okay, all right.
Oh, deeply obliged. Here.
Item 16.
Last item. Yes, translation for Patagot. So, you have received the translated copy of the evidence of PW one and PW two,
No.
the the written statement, and examination and chief and cross-examination of DW one and two. You have not received.
No, Lordship.
I have not received. Okay. So, whether it will be required for you or not?
Not required.
Not required.
Not required.
Okay.
Already discussed on elaborately discussed by the trial court. So
Okay.
everything is clear.
So, what are the substantial question of law here?
Yes.
But the issue relates to this adverse position.
Yes, sir.
So, trial court as well as the
Appellate court.
appellate court has not framed any issue on this point.
No, Lordship. There was no issue claimed so far as the first position is concerned.
But this issue was in the written statement.
Yes, Lordship.
No, the plea was taken in the written
Yes,
statement.
yes, Lordship. Hmm.
In which paragraph the plea was taken?
Lordship will find page 18.
Paragraph
Last
number.
bottom line, page 18, Your Lordship, of my appeal.
No, in WS.
This is the written statement, Your Lordship. Page 18 is the written statement
Paragraph
from
number.
page annexed to page number 17, Your Lordship.
Paragraph number
Paragraph number 12 onwards, Your Lordship.
12 onward. Okay, actual fact.
Actual fact, Your Lordship.
Okay.
Last bottom line, Your Lordship. Around 1 p.m. on 5/4/2022, defendant number 1, his mother, so-and-so, his wife and 2-year-old daughter left their house at Srivani and entered the suit house, breaking the lock and renovated the house. Page, on page number 20, Your Lordship.
Okay, on 5/4/2002
Yes,
at
Lordship.
about 1 p.m.
Yes, Lordship. And page number 20, second line, Your Lordship. Defendant number 1 has acquired the right of adverse possession over the suit land and house.
In which paragraph of the appellate court judgment
Lordship,
the
may
issue was discussed?
Lordship, first you may kindly peruse page number 33, Your Lordship.
Now, what is the paragraph number?
11, Your Lordship. Page number 13, adverse was page number 33, Your Lordship, last paragraph 11, Your Lordship. Adverse possession is a doctrine under which a person in possession of land.
No, appellate court judgment.
Appellate court, Lordship. You will find out. Lordship will find paragraph number 13, page number 48 onwards, Your Lordship.
Paragraph number 13, discussion.
Yes, point number 40.
Port
14.
number 14, Your Lordship.
Mm.
Page number 48. I have meticulously gone through the original case record of so-and-so received from the so-and-so. It is revealed that the learned
Okay, though no issue was framed
Yes, Lordship.
by the learned trial court, yet the First Appellate Court has formulate 1.4 determination
Yes, Lordship.
in respect of adverse position
Lordship.
and also recorded a finding.
Yes, Lordship.
So you see the PW2, no, sorry, DW2,
Yes, Lordship.
in his evidence, he stated that Doyamoy did.
There is
No,
the
no,
appellant here, Your
no,
Lordship.
no. That defendant Doyamoy Dev entered into the suit house in the year 2015 and 16.
Yes, Lordship.
When the suit was filed,
Suit was filed in the year 16, Your Lordship.
2016,
Yes, Lordship. Suit
2016.
filed by the
Then for how many years you have to in position?
12 years. Your Lordship.
12 years.
12 years, Lordship.
So if you entered into the suit land, suit property in the year 2015 and 16,
Yes, Lordship.
and suit was filed in the year 2016, then where is the 12 years?
Lordship, kindly see the evidence of PW1, Your Lordship. That is the plaintiff, Your Lordship. Where he has stated, since in the year 1990, I am residing in different places in locations of my service. I was in Badalpur for 12 years and I had service quarter also from 2002 to 2014.
No,
at Badalpur. And
Mr.
DW
Chaudhary,
and PW2 also supported my case.
No, no.
PW2 has stated that Your Lordship, just after purchase, Your
No,
Lordship.
you have to establish your own case by
Yes,
adducing evidence. You cannot rely upon the evidence of other party.
So far as my case is concerned, Your Lordship, I admit the fact that DW2 has stated that Your Lordship in the year 15-16, I have entered into the suit premise, Your Lordship. Lordship, the private respondent, Your Lordship, all along, though it is a case of adverse possession, Your Lordship, I have to prove my case. But fact remains is that Your Lordship, I have specifically stated from 5/4/2020, 2002, 2 year Lordship, I have entered.
No, maybe your witness has demolished your case.
Lordship, Chief,
DW2. Okay, where the record? You come to cross-examination of DW2.
Yes, Lordship. In the chief, I have stated in the year 2004, Your Lordship, but in the cross, Your Lordship, it is.
It is
Yeah,
2004 is
2014-16.
demolished in cross-examination.
Yes, Lordship. This
Then-
one aspect is there, Your Lordship, but so far as DW1 and DW3 is concerned, Your Lordship, they have supported my.
So
DW1
there is
the-
evidence that you enter into the Suitland in the year 2001.
DW1, Lordship, only thing is that, Your Lordship,
No, PW1 you cannot rely upon because you have taken the plea of adverse
this
position.
is the.
So
I
adverse
understand my
position
limitation,
has to
Lordship.
be established by you
Yes, Lordship, I understand my limitation.
by
only that-
adducing your evidence.
Yes, Lordship. Only DW2, so far as chief is concerned, he has supported my case, but in the cross Your Lordship, he has stated in the year 2015-16, Your Lordship, deposed. Otherwise, so far as PWs were concerned, Your Lordship, they have supported my case. But so far as DW, my witness, DW2 in his chief supported my case, but cross Your Lordship only.
What to do? This is clear admission.
But DW1 and 3 supported. DW1 is the appellant himself, Your Lordship. DW1, DW2, Your Lordship stated that after 2-3 years of purchase, Your Lordship, I have entered. Purchase in the year 2002, Your Lordship. And PW1 has stated this is the respondent number 1, Your Lordship. Since 2002-2014, he was out of station, Your Lordship. And I was there, Your Lordship. And trade license that has been cancelled in the year 2013, Your Lordship. Mere cancellation of trade license, Your Lordship, doesn't mean I was not in possession, Your Lordship.
And the plaintiff and the defendants both are brothers.
Yes, sir. This is not a self-acquired property, Your Lordship, not ancestral. It is a purchased land of the respondent number 1. This is the plaintiff, Your Lordship.
It's self-acquired property. And
Sorry, this is the self-acquired property by the respondent number 1, not the ancestral property, Your Lordship.
self-acquired property of the plaintiff respondent number.
Plaintiff respondent number 1, sorry, self-acquired. Not the ancestral, Your Lordship.
And regarding lordship, the document in support of their claim, they have only placed the trade license. Exhibit A, which was issued in the year 2011 and 2012. No any prior document they have filed this one to establish their claim. Rightly discussed in the appellate court judgment, page 57.18.
So in order to claim adverse position, you have to admit his title.
I am admitting his title, Your Lordship.
Ah.
The appellant has admitted he is the true owner, Your Lordship. That has been admitted. In my WS also, Your Lordship, I have admitted the fact that he is the true owner, Your Lordship. And then And so far as trade license is concerned, their stand was that in the year 2015 onwards, they have allowed me to enter, your lordship. If that was a permissive, if that is being so, your lordship, then how come the 2011-12 I got the trade license, your lordship? And that has been cancelled in the year 2013 at the instance of the plaintiff respondent, your lordship.
Mm.
Mere
Okay.
cancellation of this doesn't mean that I was not in actual possession. There
Mm.
is cancellation, this is the hostility, your lordship. One of the instances.
No, maybe trade license, on the basis of trade license, you cannot establish your claim for adverse possession.
A trade license is only for the period of 11-12, not prior to that.
2011,
11-12, period of 2011-12
granted in the year 2011 and 12.
period, not subject to any prior documents. And that was
Okay.
cancelled in 2013.
So even if we assume that it was granted in the year 2011, then also 12 years cannot be established. How can this trade license will help you
No,
in
lordship.
establishing
There-
your case?
It is their case that trade license has been cancelled at the instant of the plaintiff.
All right.
I understand
When
that has been
when the
cancelled
trade license was granted to you in the year
in the year
2011,
12, your lordship.
11,
11, 12.
11, 12.
Yes, lordship.
If we count the 12 years from 2011, then
I understand that it is within the period of limitation.
Mm.
But my case is that I entered in the year 2004, your lordship.
Mm.
No evidence, only mere.
No, so far as my evidences are concerned, my problem is that, your lordship, so far as my witnesses are concerned, DW2 in his cross deposed against me. But if I rely on, though I am not permitted, if I rely on the evidence of PW's, your lordship, it will show that PW1, PW2, your lordship, if lordship peruse that, it will show that I was there for long 12 years without any interruption, your lordship. But when it comes to DW2, your lordship, chief is okay. But cross, that is my one of the gray area, but otherwise,
Mm. Anyway, Art Mr. Soduri, learned counsel for the appellant. Let's start.
G. Gauhati.
G. Gauhati, learned counsel for the respondent. Argument concluded. Judgment reserved.
obliged.